Hello, and welcome back to Law Logical, your weekly destination for understanding the laws of the land in a simplified yet insightful manner. I'm your host, and today we delve into the 12th stage of a civil suit under the Civil Procedure Code, 1908, the stage of arguments. This is the stage where advocates bring everything together, evidence, facts, and law, to persuade the court. It's a pivotal moment in any civil litigation, and understanding this stage is crucial for anyone navigating the legal system. The argument stage, as outlined under Order 18, Rule 2 of the Civil Procedure Code, 1908, is when both parties present their interpretations of the evidence and law. This is where advocates explain why the court should rule in their client's favor. At this stage, the facts established during the recording of evidence are analyzed, and legal precedents and statutes are applied to justify each party's stance. The goal is to assist the judge in arriving at a fair and legally sound decision. The CPC provides specific rules to ensure the argument stage is conducted efficiently. Sequence of arguments, Order 18, Rule 2. The party beginning the case usually argues first, followed by the opposing party. The first party may then reply to points raised in the counter-arguments. Use of written arguments, Order 18, Rule 3a. If allowed by the court, parties may submit written arguments in addition to oral arguments. Written arguments must be concise and address all major points of the case. Court's role. Judges are empowered to ask questions during arguments to clarify any doubts. This ensures that every aspect of the case is understood comprehensively before a judgment is made. Presenting arguments requires advocates to weave together facts, evidence, and law. Here's how it's typically done. Summarizing the case. Advocates begin by summarizing the key facts and issues in the case. This sets the stage for detailed legal arguments. Referring to evidence. Every argument must be supported by evidence already on record. Advocates meticulously connect their claims to specific exhibits or witness testimonies, citing legal precedents. Advocates refer to judgments from higher courts to strengthen their case. For example, in a property dispute, they might cite Supreme Court judgments that align with their arguments. Anticipating counter-arguments. Experienced advocates preemptively address the opposing side's likely arguments, thereby neutralizing them before they're raised. Concluding persuasively. Finally, advocates conclude with a compelling summary, emphasizing why the court should rule in their favor. Let's look at a real-life example. In the case of Kusum Sharma versus Batra Hospital and Medical Research Center 2010, the argument stage played a crucial role. The advocates on both sides relied heavily on medical evidence and expert testimony to argue whether negligence could be established under consumer law. The court carefully considered the arguments, evidence, and precedents before delivering its judgment. This case highlights how thorough arguments can influence the outcome of a case. This stage underscores the importance of having a skilled advocate. A professional advocate not only knows the law, but also understands how to communicate effectively with the court. They must organize their arguments logically, anticipate and counter opposing arguments, maintain a persuasive tone without being aggressive. Their role is pivotal in ensuring that their client's case is presented convincingly and comprehensively. To wrap up, the argument stage is where the case truly comes alive in court. It's a blend of legal expertise, analytical skills, and strategic communication. Understanding this stage not only helps litigants, but also highlights the value of professional advocacy. If you found this video insightful, do like, share, and subscribe to our channel Law Logical. And don't forget to click the bell icon so you never miss an update. Drop your questions and thoughts in the comments section below. We'd love to hear from you. Thank you for watching, and see you next week as we continue our journey through the 18 stages of a civil suit under the CPC.